violation of human rights in the process, and the other two speakers dealt with humanitarian law and also civil disobedience. Now it is open to you, ladies and gentlemen. You may ask whatever question that you think is relevant, and you can post them to the speakers direct. Please identify yourself before asking the question.
I just want to make a comment, not a question. I think as President Bar Association, Mr. Kuljayasuriya clearly mentioned the Indian situation. It is very clear. And if I link that to development, in India, they have a system called public interest litigation. Thanks to Justice Bhagavati, Krishna Iyer, what they did basically, voice for voiceless people. Even any person can go to the courts and even file a case, but it should be a public interest. I like to mention the case Hyderabad. Hyderabad government, they had a road development project. Massive corruption was there, so they could not continue with that project. So what happened? One person, Indian citizen, he went to Supreme Court of India on public interest litigation. So what the Indian government, Indian Supreme Court said, we have to continue that because citizens have a right to development. Even I can remember in Geneva, there was a special session in last March 2014, right to development. And also rapporteur has been appointed. So likewise, I would like to continue, link this with Sri Lanka Millennium Development Goals, because as early morning the Honorable Minister said, developed countries are now funding for developing countries for this Millennium Development Goal. So I think that is very important. And another thing I like to mention in Sri Lanka, as you said perfectly, sending a postcard. Yes, in Sri Lanka we had a time. We had a time in Sri Lanka. I can remember Honorable Chief Justice Parinda Ranasinghe. At that time, in 88 to 90, several youths were kept in Busa camp. No case were filed. No case were filed. Thereafter, immediately, these 500 youths, they sent 500 postcards to Honorable Chief Justice Parinda Ranasinghe. If we have done something wrong, then Honorable Attorney General file us case, otherwise release us. Thereafter, immediately Honorable Chief Justice Parinda Ranasinghe gave all 500 applications to human rights lawyers. So thereafter the petition was made. So likewise, like India, we have Supreme Court rules, rule number 49(1) that can be interpreted. But very, very rarely this has been actually, practiced in Sri Lanka. So there is I also feel there is inequality, access to justice in Sri Lanka. For that, there must be some constitutional changes or amendments should be introduced. Thanks.
May I add to what Dr. Mahanama has to say about this? During that time, when His Lordship Parinda Ranasinghe, as he was then the Chief Justice, decided that all matters concerning these detainees were concerned from the camps. They were referred to the Bar Association of Sri Lanka. I happened to be the secretary of the Bar Association at that time. So we used to send busloads of lawyers to different camps and then have all this individually interviewed and prepared petitions and affidavits, and they were filed in the Supreme Court, and the relief was granted. I think even the Attorney General was very much appreciative of the process, because that was very, very much helpful to the Attorney General then. I can't remember exactly who that AG was, maybe Mr. Sunil De Silva.
Yes,
yes. And that's how nearly 3,000 applications are filed by the Bar Association of Sri Lanka with regard to those detainees. With regard to the public interest litigation in Sri Lanka, there have been many public interest litigation that have been filed. One with regard to the Epavela phosphate issue, then about the water's edge case. So there are so many cases, and judges have been equal to the task, I must say. They have taken up these issues. In fact, recently there was another case that was where I appeared with regard to the Football Federation, the national football team, the captain who said whose captaincy was deprived filed the case, and then again a preliminary objection was taken up by the other parties, saying that it is time barred. But then Her Ladyship Justice Tilakwadri, in a three-judge bench order, a well-considered order. She said that even in matters of public interest litigation, that the time bar would not be a bar. Time bar would not be a bar. So this she had held in her own other judgment in the Water's Edge case as well. So that much is there in Sri Lanka. But there are few occasions where it has been not so helpful to the public, and also I must say even the present Chief Justice has said that filing affidavits along with these applications is a fruitless exercise and that should be done away with. That's a very good suggestion. I remember when an application was filed by nearly 80 people in the case where the bomb blasted in Anuradhapura, killing nearly 32 people, and all these other people who got injured, some very badly injured, and they are bedridden, they filed this case, and for some shortfall in the affidavit and then something like that, the matter was dismissed. So it should not be the case, because as it has been often held, the court is not an academy of law. So a move to do away with affidavits, we are running into enormous problem, as you would agree, with regard to these affidavits. So that's a welcome move.
Yes, please, Dr.
Okay,
Dr. Mendes, yes.
Okay.
Yes, doctor. Mike. The mic, can you, yes, please, yes.
Shanta Hirnayaka, Deputy Vice Chancellor, University of Peradeniya.
Yes.
It's a comment and a question to Honorable Attorney General. The comment is, the world reached the equilibrium level of CO2 somewhere around 1980s, 355 parts per million. And this is the general consensus in the world, and everybody knew about it. And today, sir, it is 402. From 1985, the world knew, the states knew, the banks knew, the oil companies knew, scientists knew, except possibly the general users who are not into the science, that we are heading into possibly the greatest genocide ever. Everybody will going to die as a result of it. Now, as a person who knows that we are going in the wrong direction and something wrong is happening, if I am to take somebody to court, whom should I take? The bankers who finance the oil companies, the explorers who explore the oil, the states that facilitate this process, or the end users who drives the vehicles, or the energy companies which burns coal.
Now, I think what is necessary is you must have the legal regime for that. As I told you during the course of my presentation, whenever there is a problem or whenever there is a condition that threats the environment, the courts will be mindful of that. And we have the environmental authority, and also we have laws which prevent or which can be made use of in order to engage such situations. So you are entitled to make an application. Of course, you can make an application as a fundamental rights application if you think that the executive or the administrative machinery of the state is involved in that process. But then you have a very heavy burden to discharge. You will have to show that it affects the atmosphere and that it has caused some sort of adverse condition, adverse health condition, and so on. But I think the best way is, more than going into court, if you can bring it to the notice of the authorities and the health authorities, and the health authorities should take action administratively rather than going to court, because court may not be in a position to assess your position unless they themselves are knowledgeable in this particular area. So it would be best that you deal with it through the environmental authority and through the administrative machinery in order to bring in the solution that you are looking at. What the law can do is, law can have the legal regime in place. In fact, they have it in place through the environmental authority. and you see that these laws are being implemented in this country, and you need not take anyone to court, but if you get the administrative process in action, I think everything will fall into place. The courts will step in only if there is a violation of the laws, intentional violation of laws, knowing very well that it is detrimental to health. If there is a violation by any particular individual, then that individual will be made answerable. But other than that, I think it is an absolute necessity that all of us get together in order to move the administrative machinery, so that the administrative machinery will take place. Because now these cars, the issuing, renewing of licenses are done after a thorough examination, and issuing licenses for the purpose of businesses and also construction work, all that is done after a study of the impact that is on the environment. So we have the machinery in place. I think it was Professor Jonathan who said that the laws are there, but then the enforcement machinery needs some sort of support, some sort of proactive support from those who are behind it. So I think that is where we that is where we lack. So we should look at that. But the laws are there, I can assure you of that. Yeah, I think it affects the whole world. The World Health Organization is one of the global organizations, the United Nations organizations, and protection of the global environment is one of the major issues in the major things in the agenda of the World Health Organization. But there is no way in which you can. Now, the best example is the nuclear weapons. When the advisory opinion was sought by the General Assembly of the United Nations from the International Court of Justice as to whether the usage of nuclear weapons or nuclear power, not only in warfare, the usage of nuclear power, whether it is illegal in view of the damage that it causes to the environment. And there was only one judge who said that it does and it is illegal. The other judges, I think I will be corrected if I'm wrong, the other judges did not directly say that it has any sort of adverse impact to that extent where we could call it illegal. And that is why Justice Veeramantri's judgment is described as a dissenting judgment, not sailing with any other judges. Do you want to say something about it? About that?
About the nuclear weapons case?
No, the global environment. The question is that if there is any sort of adverse impact on the global environment as a result of any activity, what is the remedy that is available to any country? That is the question that has been posed.
Well, briefly, and then maybe you too, because you're an environmentalist. How does this work? Well, as was referred to by the Attorney General, in theory, it's possible to get on specific issues, if there's a majority in the General Assembly who would be behind that, a request for an advisory opinion from the court. Of course, an advisory opinion from the court won't resolve the issue that you're bringing up, to be frank, because what it would do would clarify the law, but the premise that you have is that the law is already quite clear, the consequences are clear. It might speed up, it might increase some of the pressure on governments. Really, as I see it, environmental law has developed quite a lot in the last couple of decades in